Justice ensures respect of the law and guarantees everyone's rights. It is delivered in the name of the people of France. Since the French Revolution, there has been a principle of duality in the justice system, with two separate streams, the judicial and the administrative streams. The judicial stream settles disputes between private persons, such as between an individual and a company, and deals with violations of criminal law. The administrative stream deals with any matters involving a public person, such as a local authority or state body. It deals with disputes between public and private persons, or between public persons. In order to safeguard this separation, the Court of Conflicts was instituted to settle disputes of competence between the two streams. The judicial stream. Any new case is brought before a court where judges examine the facts and apply the law. The best-known courts are the Assizes Court and the Employment Tribunal, but there are other types of courts too. The civil courts are competent to settle disputes between private persons. Conversely, any harm caused to persons, property and society is punished by the criminal courts. It is the nature of the case which determines which court should deal with it. In the civil courts, the competent court or judge changes depending on the nature of the case and the sum of money at stake. In certain fields, the law attributes exclusive competence to a specialized court. In the criminal courts, it is the type of offence which defines which court is competent, from the least to the most serious, a misdemeanor, an offence, and finally a crime. In the case of defendants who are aged under 18 at the time of the event, a specific set of rules applies, juvenile justice. A case can be re-examined if one of the parties disagrees with the ruling handed down the first time. This is the principle of the dual degree of jurisdiction. The Court of Appeal is competent. It assesses the facts a second time and checks whether the law was applied properly during the first ruling. It is said to rule on both the facts and the merits. An appeal to the Cour de Cassation is the last instance of appeal against a court ruling. The Cour de Cassation is the supreme court in the judicial stream. It is unique, as its role is to ensure that the law is applied uniformly throughout the land. The Cour de Cassation is not a third instance of jurisdiction. This is because the court only deals with the ruling of the lower court, as opposed to the case itself. It checks that the law was correctly applied. Although it does not reassess the facts, it does determine the merits. It also gives opinions on questions of law to those courts which request this. The administrative stream. These courts, which are separate from the courts of justice and independent from the authorities, are competent to deal with challenges against administrative acts, whether the matter involves persons complaining about an authority or different public persons arguing between them. Be it taxes, municipal elections, planning permission, or any other such matter, the administrative courts are the first courts to examine challenges against the decisions of local authorities. Appeals can be brought against the rulings of administrative courts before the administrative appeals courts. At the summit of the administrative stream is France's Conseil d'État, which serves a dual purpose. The first is to judge the acts of public authorities. The Conseil d'État is alone competent to deal with exceptional cases such as appeals against the acts of ministers. The Conseil d'État is competent to hear appeals against the rulings of administrative courts and administrative appeals courts. As the Supreme Administrative Court, it is in charge of ensuring the unity of the administrative case law. Its second purpose is to advise the government. The Conseil d'État is involved in the drafting of the most important legal texts, laws, decrees, etc. It examines them and delivers an opinion.